Introduction. In the latest flurry of motions, plaintiff filed. She now improperly seeks to silence Bonnell, that's me, and prevent him from publicly defending himself or even talking about the lawsuit. While seeking the extraordinary relief of prior restraint of Bonnell's First Amendment rights, plaintiff herself continues to attack and malign Bonnell online, including through her Substack posts, social media updates, pleas for additional witnesses to come forward, and solicitations for donations to her legal fund, all of which have been viewed collectively more than 1.5 million times. Rather than preserve fairness, as plaintiff claims to be her goal, her proposed order would ensure just the opposite. In short, plaintiff seeks to draw and benefit from public assistance while pursuing her lawsuit anonymously and muzzling the defendant at the same time. Such extraordinary relief is neither warranted nor supported by law. Plaintiff's motion should be denied. Wow, true. What an absolutely true and based argument. Plaintiffs online, were these ones that were sealed before? No. I don't know if we read these on stream or not, but they're trying to, I think they filed a motion to the court for basically a confidential, like a gag order. They want it so that I can't ever talk about my case publicly, or I can't go over any of the filings publicly, is what their goal is. So whatever. Plaintiff's online smear campaign began even before she filed her lawsuit and continues to this day. On January 20th, 2025, plaintiff published an article on Substack titled, "I will be suing Stephen Kenneth Bonnell II." That full, she got it all in there. Wherein she falsely accused Bonnell of intentionally distributing pornographic content featuring plaintiff and using a proxy to widely distribute that content. Plaintiff's Substack post is still active. Plaintiff also used her social media accounts to advertise and promote her Substack post, including on X and Blue Sky Social, in which she wrote, "I will be suing Destiny in federal court. Here's my story," and provided a link to her Substack post. Shortly thereafter, plaintiff and her friend, Lauren Dreben Hayden, created a Give, Send, Go page, similar to a GoFundMe page, to raise money to cover plaintiff's legal fees. In this case, the Give, Send, Go page includes a link to plaintiff's Substack post. In addition to her Substack and Give, Send, Go pages, plaintiff has posted and continues to post messages online, including on X using the handle @PixieLove, about Bonnell, the undersigned attorneys, and the allegations in her lawsuit. Her public statements include vitriolic attacks on Bonnell and his attorneys, regular updates concerning the rulings of this court, repeated pleas for money to fund her litigation, as well as renewed pleas for additional witnesses to come forward and testify against Bonnell. For months, plaintiff has repeatedly and publicly accused Bonnell of twisting the narrative, has encouraged potential witnesses to come forward and testify against Bonnell with a promise of anonymity, and has continuously solicited monetary donations for her purported legal fund. For example, on May 19th, 2025, plaintiff posted on X, "Please don't hesitate to contact me if you believe you might be a witness or another victim." Then just a few weeks ago, plaintiff posted the following on X. "Good news, despite opposition from Destiny's counsel," sick, "the court has granted us the ability to keep witnesses," sick, "identity under seal. If you have any information regarding the case, we can file to keep your name out of public and protected by the court. Please don't hesitate to contact me if you believe you might be a witness or another victim." Oh no. Also, please help and donate if you can to help keep the case going. Every dollar counts. Plaintiff further attacked Bonnell for allegedly playing into the humiliation/defamation/public harassment campaign that's being used to scare other victims into silence. Oh, over the Dunhams thing. Further, on May 20th, 2025, plaintiff published Bonnell's legal filings on X, publicly rebuked him, and commented on the legal issues before the court. "I suggest you reread the objection your legal counsel filed. Destiny's claiming his only issue is not having access to the redacted documents. This is extremely interesting. Destiny's attorneys were told repeatedly they would have access to the unredacted versions. That's not true. Giving them access to the names before the court could protect them would defeat the purpose of the seal. That's also not true, but okay. Prior restraints constitute one of the most extraordinary remedies known to our jurisprudence and are universally recognized to be the most serious and least tolerable infringement on First Amendment rights. The First Amendment informs us that the damage resulting from a prior restraint, even a prior restraint of the shortest duration, is extraordinarily grave. While courts have adopted varying standards to evaluate restraint, This is boring, I think. Just like you probably shouldn't be able to do First Amendment stuff, or you need a pretty high bar to muzzle somebody. Where litigation remains in its early pre-discovery posture, as here, courts are markedly reluctant to curtail speech, limiting speech by parties and witnesses, particularly in a civil case, and at such an early stage as not to be taken lightly, or is not to be lightly undertaken. Rejecting claims that early stage commentary created a likelihood of material prejudice and denying requests for sanctions or restraint where no discovery had begun, no trial date had been set. Prior restraints are permissible only in the most exceptional circumstances where speech imperils other rights, blah, blah, blah. The movement must demonstrate actual conduct that threatens to interfere with the judicial process, not speculative harm or generalized discomfort. Here, plaintiff fails to, if you had to pick a number, what percentage of things they mention is actually relevant for this case? I unironically have forgotten what the actual laws are in contention. In my opinion, I think that most of this lawsuit is just her doing as much like shoving as much random shit to basically try to destroy me in filings as possible. I think she's given up on the actual lawsuit itself, and now they're just trying to waste my time and money and tank my reputation. Courts have consistently rejected efforts to justify speech restriction, blah, 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 blah. Here, plaintiff has made no attempt to identify which, if any, specific statements from Bonnell purportedly caused her harm, nor has she articulated how any of those statements pose a concrete risk to the fairness of trial proceedings. Plaintiff's motion lists a range of grievances, alleged harassment, mischaracterization of filings, speculative commentary about witnesses, but fails to connect any of those assertions to specific statements that risk material prejudice to these proceedings. Mere recitations of harm without evidence or linkage to particular content fall well short of justifying a constitutional restraint. Plaintiff's assertion that unnamed and or yet unidentified witnesses may be deterred due to online harassment or exposure is exactly the sort of vague, unsubstantiated claim courts reject. Plaintiff's dissatisfaction with the content of Bonnell's alleged commentary online does not change that result. Plaintiff alleges that Bonnell's public commentary is misleading or misrepresentative. Even assuming her allegations are true, plaintiff fails to meet the exacting constitutional standard for the imposition of a prior restraint. Indeed, even inaccurate or adverse commentary remains protected speech. Plaintiff's allegations are speculative, or evidentiary standards are non-existent, blah, 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 blah. I don't think anything else interesting is in here. Would be interested to hear what their strategy is for winning the case. Given they're still asking publicly for money, surely just hurting financially does not justify publicly raising money under the pretense of justice. I mean, she'll never publish or post like what the money was spent on or what her legal fees were. Like that'll never be made public. If they're even charging her at all, who knows? There is a section about doe filing in a shitty way. Wait, is there? Plaintiff's ongoing publicity campaign undermines her claim of prejudice. Courts have emphasized that gag orders must apply even-handedly and that a party's own public statements can undercut any claim of one-sided prejudice. The rationale applies with even greater force here, where plaintiff has chosen to litigate publicly via Substack, GiveSendGo, and social media while attempting to bar Bonnell from doing the same. Allowing one party to broadcast their message and then invoking fairness to silence the other undermines core First Amendment protections. As stated herein, plaintiff's online smear campaign began even before she filed her lawsuit and continues to this day. In addition to maintaining a Substack and GiveSendGo fundraiser, plaintiff has posted and continues to post messages online, including on X, about Bonnell, the undersigned attorneys, and the allegations in her lawsuit. Blah, blah, blah. What caused the plaintiff's change in attitude towards you? My guess is a bunch of people yes queening her privately, and then probably Lauren driving a lot of it would be my guess. Are you sure you were referring to this? Or are you sure it's not in the other filing? Declarations of, this is my lawyer. I'm an attorney admitted to practice pro hac vice. That means with spicy sauce. In the above caption action, I'm a partner, blah, blah, blah. Submit this declaration. Exhibit A is a true plan. Exhibit B, Exhibit C, Exhibit D. Okay. Exhibit A. I can't believe that. Oh my God. This has got to be copyright infringement, okay? Jesus. Did he really need to include that? The grift is so pathetic. At least it's only mentally ill losers who are throwing their money in the trash. That screenshot. Jesus. That's brutal. Exhibit B. They switched A and B in the document. Oh, okay. In acknowledging the glaring weakness of the evidence presented in support of her motion for preliminary injunction, plaintiff belatedly attempts to submit new purported evidence to establish subject matter jurisdiction where none exists. Plaintiff's motion has been fully briefed for over a month and a half. The evidentiary hearing on plaintiff's motion already occurred. Now, on the eve of the court issuing a ruling on her motion, plaintiff seeks to submit new and untimely evidence in support of her motion, depriving Bonnell of an opportunity to respond or to challenge the declarant in open court. Wait, did they file something else by Abby? Abby MC, the anonymous person, after the hearing? Or was this about what they filed like the day before the hearing? Specifically, in a last-minute attempt, I think this is the day before our hearing for the preliminary injunction. Specifically, in a last-minute attempt to establish subject matter jurisdiction, plaintiff seeks to submit a purported text message from Abby MC, wherein Abby MC claims Bonnell sent her a video of plaintiff at an unknown time. Plaintiff had every opportunity to submit such evidence with her reply brief, or at a minimum, at the evidentiary hearing on June 3rd, 2025. Plaintiff did neither. In fact, Abby MC failed altogether to appear or testify at the hearing on the motion, thereby depriving Bonnell the opportunity to cross-examine her. Even if the court were to consider plaintiff's untimely evidence, should not, the new evidence is unauthenticated, constitutes inadmissible hearsay, and fails to establish or in any way support the court having subject matter jurisdiction over this case. Pursuant to well-established federal law, the court should decline to consider plaintiff's new evidence and strike it from the record. Factual background on April 3rd, 2025. So the reason why the Abby MC thing is important is because the whole case is basically dead, except for now they brought in this person who's claiming that I sent them a video in 2023, which I maintain is not true. That person hasn't given any evidence even to this law firm, which they admitted in the hearing, but I can't show the transcript because it's being debated right now whether they're trying to get it sealed, but they admitted in the hearing that they hadn't actually seen any evidence from her, that I'd actually sent her a video at all. It's literally just her saying it and whatever. The fact that they kind of submitted this as evidence literally the day before the hearing is a little bit silly, because the whole point of the hearing that we had was supposed to go over the evidence for the preliminary injunction. And if they really wanted a preliminary injunction, it seems like this would have been an important thing to have like submitted earlier so that both sides could fully brief it and everything. But what are you going to do? On April 3rd, 2025, plaintiff filed a motion for temporary restraining order and preliminary injunction. On April 4th, the Honorable Jacqueline Becerra, I don't want to mess that up, conducted a status conference to address the timing of plaintiff's motion. At that conference, Judge Becerra ruled that because this case had been pending since February 18th, there did not appear to be any exigent circumstances, nor a need for emergency relief. Accordingly, the court denied plaintiff's request for a TRO and referred the remainder of the plaintiff's motion to the magistrate judge to issue a report and recommendation for a preliminary injunction instead. On April 25th, Bonnell filed his opposition to plaintiff's motion for preliminary injunction. Among other arguments, Bonnell opposed plaintiff's motion on the grounds that the court lacks subject matter jurisdiction over this action because plaintiff has submitted no admissible evidence that Bonnell transmitted the video after the effective date of Cardi, which is the law that they're trying to use to sue me under. In other words, because the alleged date of transmission precedes the effective dates of the Cardi statute, Bonnell contends that there is no basis for federal question jurisdiction here. On May 2nd, plaintiff filed her reply in support of her motion, and she filed the ABMC declaration and additional exhibits to her reply a day late on May 3rd. With her reply papers in an attempt to establish subject matter jurisdiction over this action, plaintiff belatedly filed the declaration of ABMC dated April 30th. I didn't even notice that. That's funny. If it was dated April 30th and they didn't file it until May 3rd, good one. Which purported to assert that Bonnell transmitted the video to ABMC within the statutory time frame. Despite the plaintiff's motion was fully briefed a month later, and on the day before the hearing on the motion for preliminary injunction, plaintiff filed the motion to file redacted evidence in support of the declaration of ABMC. Plaintiff seeks to submit new evidence to support the ABMC declaration, namely a November 3rd text message that ABMC purportedly sent to an unknown person stating, "I have videos of him fucking Cherry and Pixie like Limfeo. He just sent me another one, haven't opened it." This is not true. Plaintiff contends that this text message directly corroborates the testimony of ABMC in her previously filed declaration. On June 3rd, 2025, the court held a hearing on plaintiff's motion for a preliminary injunction. ABMC failed to appear to testify at the hearing, and Bonnell, therefore, had no opportunity to cross-examine ABMC at this hearing. Plaintiff's new evidence is untimely and should be disregarded and stricken. Realizing, hey, Desi, I don't know if you've seen what's going on in the Mexican race, but it seems like there's a big backlash against leftists from Black and Jewish voters. Why do you think it is? No clue. I haven't followed the race enough yet. It's true that they didn't show anything. All they have is a text message from her saying that to another friend. But like, she should be able to produce videos or something to prove this as true. But remember, opposing counsel hasn't seen any of this, nor has a plaintiff. Literally none of them have seen anything. So I don't know why, when they filed this case almost a year ago, and then I don't know, over half a year ago, I don't know. No, I do know. It's all just good memes. Realizing the weakness of the evidence plaintiff has presented on the issue of subject matter jurisdiction, she now attempts to submit new evidence on the issue and deprive Bonnell an opportunity to respond. Plaintiff's new and untimely submitted evidence should be disregarded and stricken. This is in response to that ABMC declaration, I'm guessing, right? The day before, the day before. Courts routinely warn against the consideration of new or supplemental evidence in considering a motion for preliminary injunction. The interest of justice and judicial efficiency counsel against considering supplemental declarations and rulings on plaintiff's motion for preliminary injunction, blah, blah. Why don't you respond to the Jew stalker coat? What am I even responding to? Most of the stuff that is alleged over there is just like unhinged statements about me manipulating everybody or doing secret that they never have any proof for, that they never, like if there's like a text message of mine that leaks and it's me being nice to somebody, it's me manipulating somebody, or if there's like a message of me getting frustrated or upset, it's because I'm trying to intimidate people. If I admit a wrongdoing, it's because I know I'm evil. If I deny wrongdoing, it's because I'm lying. Like it's like a lose-lose. There's nothing, sorry, it's not worth, unless you think there's some specific claim or some specific thing that they've brought up over there. But usually it's all just like schizo posting. The court consider the late filed supplemental declaration, contracts radio. They cite this Butler case. Butler is instructive here. After fully briefing their motion for a preliminary injunction and after the hearing on the motion, the Butler plaintiff sought to submit new evidence, declaration in support of their motion. Court refused to consider all this, blah, blah, blah. Here in Butler, plaintiff improperly attempts to submit new evidence over a month after her motion was fully briefed and without providing Bunnell the opportunity to test the veracity and credibility of the purported witness. ABMC submitted a declaration to support a plaintiff's motion for protective order, yet ABMC refused to appear or testify at the preliminary injunction hearing. Bunnell has been denied an opportunity to cross-examine ABMC about the statements in her declaration or the exhibits annexed thereto. Accordingly, the purported evidence should be stricken. Moreover, federal courts have indicated that where a plaintiff has notice of a jurisdictional challenge, it should present its evidence at a hearing where the issue is to be addressed, or else risk waiving the right to present such evidence. Record establishes the plaintiff had an opportunity to present facts by affidavit or deposition, or didn't do it. Here, plaintiff was on notice of Bunnell's jurisdictional challenge since Bunnell filed his answer and affirmative defenses and his opposition to plaintiff's motion. Plaintiff had every opportunity to submit her new evidence with her reply brief, or at minimum, make ABMC available to testify at the evidentiary hearing before Magistrate Judge Torres on June 3rd. Plaintiff did neither. Her attempt to submit new evidence weeks later should not be given any consideration by the court. Jewstalker was hyping up the June 4th hearing, then never talked about it. Yeah, again, when you're under oath and you have to answer everything honestly, and it's like clear lines of questioning, it's a lot different than people who want to spam like one image and like scream about it over and over again on their stream. Can you explain how they are trying to link that you allegedly shared stuff with ABMC to the damages that was caused by the leak? Like, even if ABMC had received this stuff, how can there be damages related to sharing with ABMC? Who knows? Maybe there wouldn't be. That would be like the whole next step, but we're not even at that part. Like, there's not even proof because this first thing never even happened. So, but there would be so many different hoops that they would have to jump through. The issue is just that like this whole case is a fucking joke, and I think they realized it sometime a couple months ago, and now it's just extending out as long as possible, basically. His tone changed from June 3rd, laughing at your stream destiny, to saying, well, I won't go over anything unless a transcript is released. Nice. Even if the court were to consider plaintiff's untimely evidence, it should not. The new evidence is unauthenticated, constitutes inadmissible hearsay, and fails to establish or in any way support the court's subject matter jurisdiction over this case. As stated in Bunnell's opposition to plaintiff's motion for preliminary injunction, Bunnell's alleged transmission of the video preceded the enactment of the federal statute and therefore cannot form the basis for subject matter jurisdiction. Plaintiff's new evidence purports to establish that the video was transmitted on November 3rd, but it does no such thing. Here, plaintiff seeks to submit a text message from ABMC to an unknown person on November 3rd, wherein ABMC states the following: I have videos of him Cherry and Pixie like Limfeo. He just sent me another one, haven't opened it. As an initial matter, the purported evidence does not establish that Bunnell transmitted a video of plaintiff at all, let alone that Bunnell transmitted a video of plaintiff on that date or at any time after October 1st, 2022, the effective date of the Cardi statute. Plaintiff could have submitted proof of such a transmission, yet she has not done so, and for good reason it never happened. The newly submitted evidence, therefore, does nothing to establish plaintiff's likelihood of success on the merits of her motion for a preliminary injunction. At most, the proffered statement constitutes inadmissible hearsay, i.e. an out-of-court statement offered to prove the truth of the matter asserted, namely that Bunnell indeed transmitted a video of plaintiff after the Cardi statute went into effect. ABMC does not submit evidence of such a transmission, but instead submits a text message wherein she states she received a video of plaintiff from an unknown person and at an unknown time. The newly submitted evidence should be stricken accordingly. For the reasons stated herein, Bunnell respectfully requests that the court deny plaintiff's motion in its entirety. Even if the court doesn't dismiss the entire suit because of Abby, wouldn't the Rose and KF stuff get dismissed since it falls outside of the date range? Well, that's whether or not any damages resulting from that would even be a thing that she would be entitled to seek from me. That would be a whole other topic up for debate, because then the question would be like, could I theoretically be liable for damages if somebody that I'd sent something to sent something afterwards? In my opinion, the answer to that is no. But because if you're sending videos and then somebody else sends the video and then somebody else posts the video, obviously most of the damage or the vast majority of the damage is coming from the person who sent or the person who posted it publicly. Like, that's obviously the thing, but everybody wants to pretend that that wouldn't be the case, I guess, or the logistical community and all that. So, but fun times. Jessica is generally scared that either you will kill him or you will hire someone to kill him, or that someone from DGG will kill him. He constantly talks about how he's in fear of his life because a big streamer called for his death. He's mentally checked out. Nah, he doesn't believe that. And he knows it's bullshit. This is the only time I've ever made a statement that unhinged is in a private conversation with Willie. I didn't even know he would publish that. To be fair, he said that we were on the record. I just didn't think, I was just fucking rambling. I didn't know he would publish that part. But like, I've never like publicly called for anybody's fucking death, or I'm not out here like, oh, we're gonna fucking get this guy. And also, like, my community hasn't killed anybody or anything like that. Like, I'm the one who's getting swatted and, visits from the FBI and people making death threats and unhinged shit to me. And like, for him to act like some DGGer is gonna kill him is retarded. Are you cool with Willie Mac? Yeah, of course. Wait, did Willie walk back his video, or is that just indiscernible sarcasm of yours? What was I being sarcastic about? No, I'm fine with Willie. I think I probably disagree with this video, but I mean, I don't hate people for having opinions about me that they disagree with. I stayed up for like 10 hours and I read every single case that they cited in that last thing. Fucking, dude, I send the worst schizophrenic emails to my legal team. I'm like, is it normal that people cite cases like this? I didn't read this part. The authorities on which plaintiff relies are inopposite. While Gentile may be instructive here, plaintiff's reliance on the case is misplaced in that Gentile addressed restrictions on attorneys, i.e. officers of the court bound by ethical obligations and entrusted with non-public information, as opposed to restrictions on parties' speech. As the Carmichael court explained, Gentile's reasoning is inopposite, where a gag order targets a party rather than counsel. Parties are members of the lawsuit. Counsel is their litigation teams. Because civil litigants are not subject to the same professional responsibilities and have no privileged access to case information. Accordingly, Carmichael rejected the notion that Gentile's more permissive standard for restricting attorney speech could justify a similar restriction on a party, concluding that a lower threshold of proof is not appropriate under these factual circumstances, holding that prior restraints on non-attorney participants are subject to strict scrutiny. Courts have consistently recognized that limits on attorney speech do not extend automatically to parties. The court observed that lawyers in pending cases were subject to ethical restrictions on speech, to which an ordinary citizen would not be, warning that limiting parties and witnesses from making extrajudicial statements during a pending civil proceeding raises constitutional questions where similar limitations upon lawyers do not. Plaintiff's reliance on News Journal Corps fares no better. New Journal Corps involved a sensational murder trial that drew national press, televised reenactments, and repeated leaks from trial participants. The gag order imposed there was narrowly tailored, time-limited, and grounded in specific findings that extrajudicial commentary risked prejudicing the criminal defendant's Sixth Amendment rights. No such findings or comparable circumstances exist here. Likewise, plaintiff's reliance on, in response to subpoena to testify before grand jury, is misplaced. That case concerned the confidentiality of grand jury proceedings, a context governed by its own long-established secrecy rules. The 11th Circuit upheld a limited non-disclosure order based on a compelling necessity tied to preserving grand jury integrity. Courts treat grand jury secrecy as a narrow exception to typical First Amendment standards. And re-subpoena has no bearings on a civil litigant's speech in a pretrial posture. U.S. v. Brown is similarly inapplicable. That case involved a high-profile criminal prosecution of a political figure with extensive press coverage and a pattern of deliberate media leaks by both parties, including the release of sealed recordings. The court found a substantial likelihood that these statements would taint jurors in one of 3 related trials and created a carnival atmosphere. Footnote. Plaintiff claims Bonnell violated the court's order, protecting her identity by linking to a YouTube video in which her first name was briefly mentioned. This clip was posted before the Jane Doe order issued, and Bonnell promptly redacted the reference of plaintiff's first name once notified. Instead of requesting further redaction, plaintiff filed a public brief linking to the video and flagging the exact timestamp, amplifying the very disclosure she now challenges. She did this like a month later. They should have had that. These actions undercut any genuine privacy concern. They did this twice, actually, and reflect strategic opportunism, not actual harm. True and based.